সকলকে আবারও আমন্ত্রণ ক্রিমিনাল জাস্টিস প্রোগ্রাম দেখবার জন্য। আমি আজাম কো সলিসিটার্সের প্রিন্সিপাল সলিসিটর শাফিউল আজম এবং আমার সাথে আছেন আমার কলিগ ডেভিড ওয়ালব্যাংক কিউসি। David, I have to get back to you the beginning of this segment. That sentence we just started, that blood evidence used in the original trial still stood. Justice K said, not Justice.
Yeah. I suppose the point that I would make to your viewers is this: the prosecution have placed very heavy reliance at the trial on forensic evidence suggesting that the silencer that was found in the gun cabinet on the ground floor had traces of Sheila Caffell's blood on it. And it's not difficult to see why that would have been so important to the prosecution case, because if it did indeed have her blood on it, not at all easy to see how she could have shot herself, getting blood onto the silencer, then placed it in the gun cabinet, then made her way back upstairs in order to finish the job. I don't mean to sound flippant about it, but you can see why the prosecution were placing such heavy reliance on the fact that her blood was on the silencer. One of the key points, central point, at the 2002 appeal was evidence which the defence sought to place before the Court of Appeal, which they said showed that it might not have been Sheila Caffell's blood, but that the blood traces found on the silencer might have been a mixture of Neville and June Bamber's blood, of her adoptive parents' blood. Now, you're right. Lord Justice Kay said in the judgment which disposed of that appeal, in which that appeal was dismissed, that the evidence from the trial stood. Well, I suppose there are two things I'd say about that. The first thing is that it is enormously difficult, in fact, to persuade the Court of Appeal many years after the event to conclude that a conviction is unsafe on the basis of fresh evidence which wasn't referred to or placed before the jury at the original trial. There is quite a high hurdle that one needs to jump before the Court of Appeal, before the Court of Appeal will even allow you to place new evidence before the court. Essentially, you need to demonstrate that it's completely cogent evidence and explain some very good reason why the evidence either was not available at the first trial, was not available at the first trial and could not reasonably have been available at the first trial. So I don't find it entirely surprising that in the 2002 judgment, Lord Justice Kay ultimately said, no, the evidence stood. But I also think that another feature of this is that the defence really had difficulty in relation to the blood evidence because, of course, it wasn't disputed when Sheila Caffell was found that her clothes had no bloodstains on them. And, for example, her long fingernails were intact and she had no injuries and so on. And whatever else had happened at the scene, there could be no doubt from the other evidence in the case that there had been a violent struggle down on the ground floor between whoever was responsible for the killings and Neville Bamber. So whatever the forensic evidence showed back in 1986 and then again in 2002 about the blood on the silencer, that didn't really help the defence on the question of why it was that Sheila Caffell, when she was found, was free of bloodstains, and that has undoubtedly influenced both the prosecution and the jury in 1986 and the various appeal courts and review courts which have looked at the case since. That's what I'd say about the blood stain evidence.
Yeah, thank you. দর্শক আপনারা শুনছেন ডেভিড ওয়ালব্যাংক কিউসির কাছে। এই ব্যক্তি, he angered his surviving family when he offered a £1 million reward for any fresh information which would help him have his sentence quashed. সে তার পরিবারের সদস্যদেরকে খুব ক্ষুব্ধ করেছিল, অ্যাঙ্গার্ড করেছিল, খুব রাগান্বিত করেছিল যখন সে £1 million একটা রিওয়ার্ড সে ডিক্লেয়ার করেছিল একটা ফ্রেশ এভিডেন্সের জন্য, ফ্রেশ ইনফরমেশনের জন্য, যেটা তার সেন্টেন্সটাকে কোয়াশ করা যাবে। মানে সেন্টেন্সটাকে কোয়াশ করা মানে সেন্টেন্সটা তার ফিনিশ করা যাবে। In 2011, he tried to appeal for a third time against his conviction. সে তৃতীয়বারের মতো 2011 সালে কনভিকশনের এগেইনস্টে সে ট্রাই করছে আবার। But the Criminal Cases Review Commission said it had previously decided not to refer his case to the Court of Appeal. বলছে কি ক্রিমিনাল কেসেস রিভিউ কমিশন যে তারা ডিসিশন করেছিল যে তারা এটা কোর্ট অফ অ্যাপিলের মধ্যে পাঠাবে না। He also lost a 2009 appeal. 2011 সালের আগে 2009 সালেও সে অ্যাপিল লস করেছে to reduce his full life sentence to 25 years. যে তার সেন্টেন্সটাকে লাইফ সেন্টেন্সটাকে রিডিউস করে 25 ইয়ার্স আনা হোক, ওইটাও সে লস করেছিল। Judges told him the extreme gravity of the sentence. যে জাজ বলছিল কি যে খুবই এটা the extreme gravity of the offenses, extreme gravity of the offenses justified their decision he should die in jail. এবং জাজ বলছে কি the extreme gravity of the offense মানে ভার, গ্র্যাভিটি মানে ভার, খুবই ভারী অফেন্স, খুবই অপরাধটা খুবই বড় অফেন্স, খুবই ভারী, এবং এই অপরাধের জন্য জাস্টিফাই হয় যে সে জেলখানায় মরতে হবে, he should die in jail. David, if you can just for the viewers, what this CCRC, Criminal Cases Review Commission, what do they do?
Well, their essential function is to try to reduce to the minimum possible number cases which involve miscarriages of justice. Until the setting up of the Criminal Cases Review Commission, the only way in which a case could get before the Court of Appeal was for a defendant, an appellant, to seek to persuade either a single judge of the Court of Appeal, or if a single judge refused leave, a three-judge court of the Court of Appeal, that there was some real merit in the appeal and they should entertain the appeal and have a full appeal hearing. And there were, without getting too legalistic about it, there were constraints that were placed on the number of times that somebody could appeal. Essentially, once you'd had one full appeal and your appeal had been dismissed by the Court of Appeal, the opportunities that you had for making any further appeal were very limited indeed. The Criminal Cases Review Commission essentially was set up as a body which would have the capacity to investigate in particular complex and in particular historic cases, which the Court of Appeal might otherwise struggle to get a grip on. And as I say, essentially, it's intended to minimise the number of miscarriage of justices. It has an investigative function. It has people who can carry out inquiries in relation to cases that are referred to it. And ultimately, the Criminal Cases Review Commission has to make a decision whether to refer a case to the Court of Appeal. If they do refer the case, the Court of Appeal has to entertain the appeal. The Court of Appeal can't refuse to hear the appeal if the Criminal Cases Review Commission refers it. And the test that it applies is sometimes described by lawyers as being a predictive test. In effect, the Court of Appeal, the Criminal Cases Review Commission essentially makes two different predictions. the prediction it has to make in every case is whether the Court of Appeal is likely to overturn the conviction in the event that the case is referred to the Court of Appeal. And the second prediction it has to make is based on the fact that many cases that go via the Criminal Cases Review Commission are based on fresh evidence, which is said not to have been available at trial and couldn't have been available at trial. And so the Criminal Cases Review Commission actually has to make a twofold prediction. Is the Court of Appeal likely to accept the new evidence and take into account the new evidence? And if it does accept the new evidence, what effect is that new evidence likely to have on the view of the Court of Appeal? And is the Court of Appeal then likely to overturn the conviction? So that's a very sort of that's a very rule of thumb, a very brief summary of what the.
Thank you very much. That explains very well. Yeah. দর্শক ডেভিড ওয়ালব্যাংক ইউএসএ উনি he prosecutes, he defends. তার মানে he prosecutes and he defends. মানে হচ্ছে ওনাকে পুলিশ ইনস্ট্রাকশন দেয় কেস করার জন্য পুলিশের পক্ষে। আমরা যারা সলিসিটার, ডিফেন্স সলিসিটার, we also instruct him. Very experienced উনি আপনাদেরকে বলছেন ওনার এই কেসটা আপনারা যদি যান crimecast.law, more details about this case. এখানে আজকে আমাদের সময় খুবই কম, এই সংক্ষিপ্ত সময়ে সব ডিসকাস করা সম্ভব না। You can visit his site crimecast.law. অনেকগুলো কেস আপনি দেখবেন উনি কত হার্ড ওয়ার্ক উনি করেন। Bambers is one of 3 convicted murderers, each given a whole life tariff, who have applied to the European Court of Human Rights on the basis that their lifelong detention amounts to inhumane and degrading treatment. এই ব্যক্তি ইউরোপিয়ান কোর্ট অফ হিউম্যান রাইটস এর মধ্যে সে অ্যাপিল করেছে এবং সে বলছে কি তাকে যে লাইফ লং যে সেন্টেন্স দেওয়া হয়েছিল এটা হোল লাইফ মানে ট্যারিফ মানে পুরো আজীবন যেটা বলা হয় আমরা বাংলায়, এটা একটা ইনহিউম্যান, এটা অমানবিক এবং এটা খুব ডিগ্রেডিং, এটা খুব নিচু পর্যায়ের ট্রিটমেন্ট। Throughout his locked up, he has continued to make headlines. তার কেসটা কিন্তু বিভিন্ন পত্র পত্রিকার মধ্যে সব সময় আসছে। Beyond appeals against conviction and sentence, he has also lost high court claims for £1 million from his grandmother's will and about 300,000 for being unfairly frozen out of his family's wealthy caravan side farm. সে অ্যাপিল ছাড়াও সে আরো অনেকগুলো কেস সে লস করেছে। £1 million উইল ইনহেরিট করা উত্তরাধিকার ক্লেইমস, যেটা তার উইল থেকে পাবো ওইটা সে পায় না, এবং তার আরো ক্যারাভান ফার্ম থেকে £300,000 যে অ্যামাউন্ট ওইটাও আনফেয়ারলি ফ্রোজেন করা হয়েছিল, ওইটাও সে পায় নাই। He has also unsuccessfully attempted through the courts to have his security status downgraded from a highly dangerous category A prisoner to category B. আপনারা জানেন category A prison, category B is more আপনার free prison, category B টা, এবং সেখানে সে যেহেতু সে ক্যাটেগরি এ যেটা খুব স্ট্রিক্ট আপনার ওখানে মুভমেন্টটা ওই প্রিজন থেকে ডাউনগ্রেড করার জন্য ক্যাটেগরি বি তে যাওয়ার জন্য চেষ্টা করছে কোর্টে, কিন্তু কোর্ট সেটা তাকে গ্রান্ট করে নাই। In 2004 he needed 26 stitches after another inmate at York's Fullerton jail slashed his neck while he was working on his phone. জেলখানার মধ্যে সে যখন তার টেলিফোনের মধ্যে কথা বলতেছিল, আরেকজন কয়েদি, আরেকজন প্রিজনার তার নেকের মধ্যে, তার গার্ডের মধ্যে আপনার স্ল্যাশ করে দিয়েছিল, ছুরি দিয়ে আপনার কেটে দিয়েছিল তার স্ল্যাশড তার গার্ডের মধ্যে, যার জন্য তার 26টা সেলাই দিতে হয়েছিল তাকে, 26টা 26। The case of Essex killer Jeremy Bamler will not be referred to the Court of Appeal, the Criminal Cases Review Commission said in February 2011. যে সিসিআরসি, যেটা আমার কলিগ ডেভিড ওয়ালব্যাংক কিউসি এক্সপ্লেন করছেন, ওনারা বলছেন কি এইটা কোর্ট অফ অ্যাপিলের মধ্যে রেফার করা হবে না। He was jailed for shooting his adopted parents, তার পালক মা বাপকে সে হত্যা করেছিল, his sister, তার বোনকে হত্যা করেছিল, এবং his sister's 6-year-old twin son, 6 বছরের বয়স্ক দুইজন মানে ছেলেকে তাদের ফার্ম হাউসের মধ্যে। A spokesman of the family said they were very relieved by the CCRC decision. David, I come to you for your comment on this point. CCRC decision made in February 2011, and then family said very relieved. What's your comment?
Well, in a sense, it really goes back to my last answer to you, Shafi, about the way in which the Criminal Cases Review Commission goes about its work. It has to make a prediction about two main things: whether fresh evidence, which is brought to the attention of the Criminal Cases Review Commission, is likely to be accepted by the Court of Appeal, and whether the Court of Appeal is likely to take account of that fresh evidence. And the second prediction it needs to make is whether, if that fresh evidence is taken into account by the Court of Appeal, it is likely to lead to the Court of Appeal overturning the conviction. It's called the jury impact test. What would the effect on the jury's deliberations have been of that new evidence if that had been before the jury? And having referred the case once to the Court of Appeal back in the early 2000s, resulting in that appeal which was heard and dismissed by Lord Justice Kay in 2002, the Criminal Cases Review Commission has consistently since then declined to re-refer the case. And speaking for myself, I can understand why the Commission has been reluctant to re-refer the case, because frankly, once there's been a full referral and a full appeal hearing, and the Court of Appeal has rather robustly dismissed the appeal, it is not entirely surprising that the Commission takes the view that a re-referral of the case is unlikely to have a different result. It would have to be some really striking new evidence on the face of it, going before the Court of Appeal to change the court's mind. I mean, it's sometimes said that the effective test, the practical test in real terms that is applied in relation to new material leading to a conviction is that it will have to be new evidence or new material which would in effect determine the case one way or another, demonstrate to any sensible observer that a miscarriage of justice has occurred. That will tend to be some new forensic evidence being discovered which makes plain that the original verdict was unsound, or, for example, some new scientific technique being developed which wasn't available to the defence at the time of the initial jury trial, and that that new scientific technique gives rise to evidence which really proves beyond doubt that the original conviction was unsafe. The High Court, in the most recent case, the 2020 hearing, referred to that sort of evidence which really determines a case in favour of an appellant, and made the point that the present case was a world away from that. They referred to the significance of the silencer at the first trial. They referred to the fact that there was in fact no direct evidence that there'd ever been a second silencer, that the suggestion by defence counsel that had been told that there was a second silencer had been disputed by 3 different Queen's Counsel who'd acted at different times for the prosecution. But in the end, the court said in 2020, so what? Even if there was a second silencer, none of the material that the court had seen suggested that the existence of a second silencer would have affected the safety of the conviction in any meaningful way. They entirely acknowledged the expertise of the ballistics and firearms expert, on whose expert opinion evidence the Bamber team was seeking to rely. But the court made the point in 2020 that that new expert evidence had to be evaluated against the whole corpus, the whole body of evidence in this case. And the court said, overall, the claimant's arguments, the appellant's arguments were speculative, and the requests for disclosure that he was making to the Crown Prosecution Service amounted to what lawyers call a fishing expedition. And ultimately, the court in 2020 took the view that the CPS hadn't made any error, no error of law, in declining to make further disclosure in relation to this question of whether there was or was not a second silencer found at the scene.
Yeah, it's very well explained. There is a lots of information. I know we are under constraint of time. What I am thinking, it is such an interesting the case, and it's such an important, remarkable the case. I think we will talk on this case again with some more depth in the next program. And then people understand how it is important to get the right legal expertise. The Queen's Counsel in the murder case is so vitally important. Recently, আমার একজন আমাকে approach করেছে একটা murder কেসের জন্য। আমি তাদেরকে I tried to explain to them how important to get them experience. He was telling, I've got the barrister for the this many years. I said, no, we have the Queen's Counsel. So it is so important. The gravity of this case shows how important to get the experienced, competent legal team. So we will hopefully again talk on this case with some more depth, because there's a lot to say. This is a very, very the important case. Continue this case maybe in the next program again. We have time. We will go on. Yeah. So we don't go for another question now. দর্শক, আমরা যেটা কেসের উপরে বলছিলাম, এটা very important, যেখানে এই ব্যক্তি তার পালক মা, বাপ এবং তার বোনকে এবং তার টুইন সান দুজনকে সে হত্যা করেছিল সম্পদের জন্য, ইনহেরিটেন্সের জন্য। এটাই হলো কেসের সারমর্ম। তাকে 5 জনের জন্য 5টা লাইফ ইমপ্রিজনমেন্ট তাকে দেওয়া হয়েছিল, এবং সে 1986 সালে তাকে কনভিকশন করা হয়েছিল। হি কন্টিনিউয়াসলি আপনার অ্যাপিল করে যাচ্ছে। ডেভিড ওয়ালবেঙ্ক কিউসি উইল টক অন মোর আপনার এই কেসের উপরে। আমরা নেক্সট প্রোগ্রামের মধ্যে, সে এখনো 2020 সাল, সে 1986 থেকে 2020, তার মানে কয় বছর হলো? প্রায় 35 বছর, 36 বছর সে কন্টিনিউয়াসলি কেস ফাইট করে যাচ্ছে। সে কোর্ট অফ অ্যাপিলে যাচ্ছে, কনভিকশনের অ্যাপিল করতেছে, সেন্টেন্সের অ্যাপিল করতেছে, সে ক্রিমিনাল কেসেস রিভিউ কমিশনে যাচ্ছেন, চ্যালেঞ্জ করতেছেন, সে বসে নাই। সুতরাং সাথে সাথে আপনাকে লিগ্যাল টিমও, এক্সপেরিয়েন্সড এক্সপার্ট লিগ্যাল টিমও আপনাকে রাখতে হবে। হয়তো কোর্ট গ্রান্ট করতেছে না, বাট ইউ থিঙ্ক দ্যাট ইউ হ্যাভ এ কেস, বাট ইফ ইউ হ্যাভ এ কেস, ইউ নিড দ্য এক্সপেরিয়েন্সড লিগ্যাল টিম টু check the merit of your case to see whether there is any ground. সময় শেষ হয়ে গেছে। আজকের প্রোগ্রামটি আবার পুনঃপ্রচার করা হবে নেক্সট টুইসডে, ঠিক একই সময় দুপুর 12:30 থেকে 2টা। তাছাড়া এনটিভি ইউরোপের ফেসবুক এবং ইউটিউব চ্যানেলে লগ ইন করলেও আপনারা প্রোগ্রামটি দেখতে পারবেন। তাছাড়া সলিসিটর শাফিউল আজম অথবা আজাম এন্ড কো সলিসিটরস নাম লিখে গুগলের মধ্যে দিলেই, সার্চ করলেই আপনারা এই প্রোগ্রামের লিংক পাওয়া যাবেন। সবাই ভালো থাকুন, সুস্থ থাকুন, এবং সকলের প্রতি আমার শুভকামনা থাকলো। আসসালামু আলাইকুম।